This is an in-person meeting and it's being held at the University of Hawaii in Hilo. So nice to be back in Hilo after 2 years. Please be aware that this meeting is being recorded via Zoom and court reporting will be done from the digital record. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into the microphone. Before speaking, please state your name and identify yourself for the record. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. My name is Dan Giovanni, and I currently serve as the Land Use Commission Vice Chairman, and I will be conducting the proceedings today. We currently have 9 seated commissioners. Along with me today are Commissioners ACZON, Don Chang, Nancy Cabral, who is from Hilo, representing the Big Island, Gary Okuda, Lee Ohigashi from Maui, Arnold Wong, Kuiki Kamakea, Jonathan Schroyer, our normal chair, is excused from today's meeting. Also with me is staff, LUC Executive Director to my left, Daniel Orendenker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Riley Hakoda, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Natasha Quinones, and to my right, LUC Attorney General, Julie China. All are present today. As I said earlier, court reporting transcriptions are being done from this Zoom recording. Our first order of business is to adopt the minutes from the meeting of May 11 and 12, 2022. Ms. Quinones, has there been any written testimony submitted on this matter?
Good morning, Vice Chair. No written testimony was received on the minutes.
Thank you. Are there any members of the public who wish to testify on the adoption of the minutes from the meeting of May 11 and 12, 2022? If so, please raise your hand to be recognized. You will then be called upon to the witness chair and given 2 minutes to testify. I see none, so we will proceed. Commissioners, are there any corrections or comments on the minutes? If not, Commissioner Cabral.
I'd like to make a motion to approve the minutes as presented and also commend our staff for the excellent job of getting these turned around in such a short time frame. Thank you.
Thank you, Commissioner Cabral. Do I have a second?
Chair, I second. This is Commissioner Wong.
Thank you, Commissioner Wong. Commissioner Cabral has moved to adopt and Commissioner Wong has seconded. Does there anybody have any corrections to the minutes? Mr. Orendecker, please poll the commissioners.
Thank you, Mr. Chair. The motion is to adopt the minutes. Commissioner Cabral.
Yes.
Commissioner Wong.
Aye.
Commissioner ACZON.
Aye.
Commissioner Chang.
Point of clarification, Dan. How many commissioners do you need to approve the minutes?
Aye.
I'm not going to participate since I was not at the meeting.
Okay. Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Yes.
Commissioner Kuike Kamakea Ohelo.
Point of clarification as well, then. I was not in attendance on May 11th. So I will be recusing myself from the vote.
Okay, thank you. Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes with 1, 2, 4, 5, 6 votes.
Thank you, Mr. Ondecker. Our second order of business is the tentative meeting schedule. Mr. Ondecker?
Mr. Chair, on May 25th, we will be on Oahu for a continuation of the KS Waiava matter. Our next meeting after that scheduled right now is June 22nd for any additional KS Waiava matters. On July 27th and 28th, we will be having training on the island of Oahu from 9 to 3 p.m. at the Aloha Tower, both 27th and 28th. And that is currently all we have scheduled. I would caution the commissioners that we do have a couple of short time frame petitions there we're waiting receipt of, so I would keep the dates open. We were trying to keep the dates open until such time as you hear otherwise. Thank you.
Commissioners, any questions on the schedule? Commissioner Cabral?
Yeah. Should we continue to somewhat reserve the second and the fourth Wednesdays and Thursdays for the balance of my life?
Yes, Commissioner, that's correct.
Okay, thank you.
We will now move forward to the third agenda item for today. This is an action regarding docket number DR 21-72. Kenneth S. Church and Joan E. Hildal of Hawaii to consider the petitioner's motion for reconsideration of order denying the petition for declaratory order and reimbursement and waiver of fees filed March 15th, 2022. Pursuant to Hawaii Administrative Rules, Section 15-15-84.
Mr. Chair,
Yes, Commissioner Wong.
We apologize for being late. We had 3 road closures coming in and detours, which wasn't planned for. We planned for 1. Anyway, Mr. Orodenker wrote us a letter. I don't have it in front of me, but in the last 2 weeks that said that this hearing may also address a letter that we had sent in just prior to the last hearing as to whether we would be able to have a contested case hearing. I believe I could read it out, but.
Mr. Church, the subject at hand is a motion to go into executive session. Do you have any comments specifically on that?
No.
Thank you. Anybody else have any additional comments? We will adjourn and go to Commissioner Wong.
Chair, you have to take a vote on that, sir.
Have to take a vote.
Yes.
Mr. Undecker, can we have a vote, please, on the motion to go into executive session?
Motion has been made to go into executive. Oops, sorry. Motion has been made to go into executive session. Commissioner Wong,
Aye.
Commissioner Okuda,
Yes.
Commissioner Ohigashi,
Yes.
Commissioner Giovanni,
Aye.
Commissioner Chang,
Aye.
Commissioner Cabral,
Yes.
Commissioner Exxon.
Aye.
Commissioner Kamakeo Hill.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, so we will be going into executive session, so we'll excuse everyone from this room and we'll have this executive session in here. And the commissioners and the AG and executive director will remain. So with that, I can ask everybody else to excuse themselves from the meeting room, and we'll call you back into session when the executive session is completed. Thank you.
Mr. Chair, point of clarification, I'd like to have staff remain to take minutes for the executive.
We will agree to that as well. Executive staff for the commission will remain as well to take minutes.
God, I don't want to take.
Minutes.
9:37 by my clock. We've completed executive session and we're going to resume on the third agenda item, docket DR 2172. Will the parties please identify themselves for the record?
My name is Ken Church. I'm the petitioner or the motion movement.
Petitioner. Thank you, Mr. Church.
My name is Joan Hildal. I'm the other petitioner.
Thank you. Before we begin, let me update the record. September 8th, 2021, the commission met via Zoom and heard petition for declaratory order for boundary interpretation for DR 2172. Church Hildal, petition was denied. On October 4th, 2021, the commission received an email from the petitioner with a notice of objection to declaratory order process. Also on that date, the commission received an email with Executive Services casework number 70226 from the petitioner. On March 15th, 2022, the LUC issued an order denying the petition for declaratory order and reimbursement and waiver of fees and mailed a copy of the order via certified mail and emailed to Mr. Church. Also on that date, the commission emailed the order to the county and the Office of Planning and Sustainable Development as a courtesy. On March 28th, 2022, the petitioner filed his motion for reconsideration. On March 31st, 2022, the commission received OPSD's letter informing that they have no further comments and did not intend to participate or attend this hearing. On April 18th, 2022, the LUC mailed and emailed the LUC's agenda for today's meeting to all parties, statewide and county agenda lists. On April 4th, 2022, the commission received the petitioner's letter and request to postpone the meeting. On April 25th, 2022, the commission emailed the meeting cancellation notice to the parties statewide and the county agenda lists. On May 10th, 2022, the commission mailed and emailed an LUC agenda for May 19th, 2022 to all parties statewide and county agenda lists. On May 10th, 2022, the commission mailed a letter to petitioner notice of a new meeting date. On May 13th, 2022, the commission received the petitioner's filings for motion to reconsider cover letter, index, introduction, staff reports, errors, final D and O errors, exhibits AA, BB, CC, D, E, F, G, H, J, COS. Now, let me briefly run over our hearing procedure for this docket. First, I will give an opportunity for the petitioner to comment on the commission's policy governing reimbursement and hearing expenses. Next, I will recognize any written public testimony that has been submitted to this matter, identifying the person or organizations who has submitted the written public testimony. Then I will call for those individuals in the audience who want to make public testimony for this docket. Please note, there is a sign-up sheet located on the table at the side of the room. Those who wish to provide public testimony should sign up, and we will be making public testimony in the order from this sheet. Please wait for your name to be called and come forward to testify in the witness chair. Please note that we will be calling the names of the next person on the list if there are more than one person. After completion of the public testimony portion of the proceedings, I will call the petitioner to make its presentation. After the petitioner's presentation, we will hear commissioners' questions or comments. Finally, the commission will enter deliberations. I would also like to note for the parties that from time to time, I will be calling for short breaks, approximately 5 to 10 minutes every hour. Are there any questions for today's proceedings? Petitioner?
Proceedings, Ken, only
It
proceedings.
seems that in your background list of relevant information that are before you, one item is missing, I believe, and that's the February motion for a boundary interpretation that was in front of all of this.
February what date?
It was May 20th.
No, I think it was either the 7th or the 9th.
What year?
Of 2022, and it's on your website.
Oh, it was 2020.
Oh, it would have been 2021, sorry.
Could you please restate? I couldn't follow your ramblings there, so.
Okay. Before this process started, we first filed a motion for a boundary interpretation that the commission determined that. And that was filed in February of last year.
And also boundary interpretation.
Yeah, these proceedings and this summary that I presented cover the proceedings and matters since our decision in March, not before that.
It was discussed in your decision in March.
And I did acknowledge the March proceedings.
Okay.
Thank you. Commissioners, any other questions? Okay, next order of business. Good morning, Mr. Church and Ms. Hildal. Have you reviewed HAR section 15-15-45.1 with regard to the reimbursement of hearing expenses?
Yes,
Do you agree to adhere to this policy?
yes.
Thank you. Now we'll proceed with public testimony. Ms. Canones, has there been any written testimony submitted on this matter?
No written testimony has been received on this matter.
Thank you. Are there any members of the public who wish to testify on this matter? Please raise your hand to be recognized. Thank you. Seeing none, we'll proceed. So the Office of Planning and Sustainable Development has stated its position in writing and has chosen not to appear at this hearing. Let me also acknowledge for the record that the County of Hawaii has chosen not to appear at this hearing. So, Mr. Church, now we're going to proceed with your presentation. And I'd like to provide you some guidance from the chair to help assist. So first of all, there's a very exhaustive record on this matter. A lot of testimony has been received from you, and I have received assurances from my fellow commissioners, and let me assure you that we have reviewed all of that in detail in advance of the hearing today. I'd also like to refresh what are the standards that we have for this consideration that you're bringing forth. Primarily, the move on, which is you, has to show new evidence and evidence that could not have been brought up in the prior hearing that you are asking for, which you're asking for reconsideration. Reconsideration of a decision can be based on a motion, which is your motion for reconsideration. It needs to state specifically the grounds on which the movant, you, considers the decision that we made to be unreasonable, unlawful, or erroneous. So we'd like to focus your presentation on those matters. We also ask and direct you to really emphasize new information that you'll be bringing for our consideration, new information that is not currently on the exhaustive record that we have already reviewed. And in this context, we ask you to confine your presentation to 1 hour. And in that hour, you may use your time as you wish to bring forth what you think is of the most salient and important information you would like us to consider relevant to your motion for reconsideration. So let's proceed. I'll hand it back to you.
Excuse me, Mr. Chair.
1 second, Commissioner Okuda.
Thank you, Mr. Chair. Just so that the standard is clear, may I ask someone to actually read the standard from the administrative rules?
Yes.
I did.
Okay, well, I just wanted a clarification then, because I'm not sure if the standard said that it had to be evidence that could not have been presented earlier.
That was my guidance in the sense that we have an exhaustive record, which we're all familiar with. And I encourage them to use their time wisely to focus on new information. But the standard, and I'll read it again for the record, the motion for reconsideration, it's 15-15-84, reconsideration of a decision, section B. The motion for reconsideration shall state specifically the grounds of which the movant considers the decision or order unreasonable, unlawful, or erroneous.
Thank you, Mr. Chair. I stand corrected.
Thank you. Okay, anything else? It's currently 10 minutes till 10. So assuming we take a 10-minute break within the next hour, we'd like you to shoot to complete your presentation by 11 o'clock.
I will first say that that's an unlikely timeline. If I can remind the commissioners, they said that we did not give them a preponderance of evidence nor a burden of persuasion. We didn't meet those standards. So we have new evidence. We have to deal with the staff memorandum, which we feel was improper before the commission in the last hearing. And we have the declaratory order to deal with because there's errors in it. As well as the new information, the transcripts of the 1969 hearings. And if I can just refer to them as transcripts, one of them is a minutes of meeting, but There's 3 transcripts. They're generally 100 pages, and they have a lot of information in them. And again, I'll remind that we were told that we didn't meet the burden of persuasion or the preponderance of evidence. So we want to go through that. The hearing before did not properly acknowledge. We had stated repeatedly in writing and during the hearing that HRS 2052A3 was applicable legal authority. And in no way is it discussed was it discussed during the hearing other than us raising it a few times? And in the declaratory order, it wasn't. So we have a lot of ground to cover. And I can assure that 1 hour, and there's 2 of us, so we're 2 petitioners. 1 hour isn't going to meet that standard, not even close.
Let me remind you that we have read your briefs. We know your position as you've expressed it on the record. You've just wasted, in my judgment, 5 minutes of your hour. So please proceed.
Well, I'll give it to my wife. She has an opening statement.
Thank you.
So I guess, hello, my name is Joan Hildal.
Can you bend it up a little bit?
Sure.
Thank you very much.
There you go. So concerning whether the procedures were erroneous, I wrote a list of my objections to the previous hearing. And the first one was the fact that we weren't allowed to present our case as we had prepared because they cut off our video feed immediately, so we had no chance to present our case at all. So the second part of that is the questioning by both the chair and the commissioners were completely about things that didn't have anything to do with the declaratory ruling, which is whether the districting was correct or the boundary interpretation was correctly written. So the procedure was actually wrong too. And I think there was also a confusion about whether this was based on 101, where the 4 different denials would have been A, B, C, or D, or a contested case hearing, which would have been the preponderance of evidence and burden of proof. But if we didn't get a contested case hearing, burden of proof and preponderance of evidence shouldn't have been the standard. So it was a big confusion for us what we were dealing with right from the very start. So I guess for those reasons, we objected to the initial hearing. So I'd like to do my opening statement. It'll take about a half an hour. Is that all right?
It's your hour. You can use it any way you wish.
Okay, so we're only going to get 1 hour.
That's the guideline I'm giving you, yes.
What do you want to do, Ken?
We simply want to go on the record that we object.
So noted.
Okay. Aloha, good morning, everybody. We've seen each other a lot already. I'm really sorry about that. We're just trying to get the right, correct thing, and we expect your impartial decision after this. Anyway, good morning and mahalo for considering my opening remarks. This hearing has always been about the facts at the time of the property's apparent redistricting and the subsequent boundary interpretation 9248, nothing more. It is simply about removing the continued uncertainty that exists from the apparent redistricting that designated an ag conservation boundary line on a property that was fully agriculture without including any associated date of redistricting, associated law, or authoritative lawful reference, as many other boundary interpretations include. There is no evidence that anything other than the inconclusive SLUD maps had been used in the designation of the conservation redistricting in 1969 or the subsequent boundary interpretation in 1992. So sadly, uncertainty remains after all these years. We respectfully ask for your open-minded attention, patience, and consideration in order for you to make an impartial decision based on proven facts and established policies as required in Act 193, Section 1. The commission is constructed as a quasi-judicial body and mandated to make impartial decisions based on proven facts and established policies. You can put 193 up there if you want. Okay. And there's Act 193 if you want to refer to it. We discovered late.
1 second. So
Okay.
when you say there is, are you referring to the,
Act.
no, are you
193.
referring to the projection on the screen?
Yes, sir.
Please make that clear so that we
Oh.
can,
Okay. So on projected, we're going to project a lot of our.
so when you
map.
want us, when you refer to it, just please note it, it's on the screen.
Okay. We discovered late that the boundary interpretation in question, boundary interpretation 9248, actually contained no stated foundation in law. It is not settled law until determined to be factually based after applying the laws and policies that existed at that time, and then determined by the commission or a court of law. So uncertainty remains. We are blessed that Hawaii law allows its citizens the right first to request additional boundary interpretations, which we did, but we got no response. And then if uncertainty still remains, to request a determination upon written application, which we also did to correct the uncertainty that still exists. Uncertainty still exists because it does not appear that the LUC at the time of redistricting, or even at the time of the boundary interpretation, considered the state's interests, Hawaii's constitutions, Hawaii's laws, or applicable legal authorities like the 1969 Boundary Review Report stated to be the applicable legal authority from which the maps were to be made to correctly make the designation of agriculture for this property. Property owners have suffered economic and vested use loss because of those errors. Here, the question is clear and the facts and policies necessary to determine the questions presented simply whether the districting in 1969 or the boundary interpretation may have been made in error. The only matter for the commission to decide is the application of the law, state's interest, according to those undisputed facts. State interest defined is a broad term for any matter of public concern that is addressed by a government in law or policy. So here we are. So compare Stengel, Moragan, and Macaulay boundary interpretations. DR 99-21 Stengel. Oh, here's the screen, sorry. It's the Stengel map is on the screen for you to look at. DR 9921's order should have the same force and effect as it has the same factual situation as our DR 2172. It was an intensive ag use at the time of redistricting. The apparent line on the map bisected the intensive ag use of the property that went right up to the poly. It also had a railroad transecting the ag use. Original maps are not available, so it's difficult to know where the original line was.
Ms. Hildal,
Yes.
I just want to affirm, to my recollection, all of this information was in the record and presented in the hearing. And you're repeating that again.
This map order?
If you recall,
This is not new information to the
well, it
commission.
is.
How is it new?
There was a discussion
We weren't
by
allowed to show it
Commission
before.
You did
Chair.
not show, the commission is not aware of this,
No, we weren't allowed to present it in our previous hearing. We had prepared this whole thing to present in our last hearing and they cut off our video.
Yeah, I'm just trying to clarify.
Yeah,
At the last hearing, did the commission have an opportunity to see this exhibit?
no,
No,
Okay, so then proceed and we'll look at the exhibit.
and I
Okay.
want to say why it's significant, because it'll apply to the Moragan one and to ours. Scheuer had a discussion with Maki regarding whether there was a comparable property where there was a district
Sure.
boundary and there.
Chair,
Second, Commissioner,
we have one petitioner at a time
Okay,
speak because I just was trying to follow her argument and
I'm fully distracted now.
lost.
Yeah, I don't know where he's going with that, so it's not helpful. Let's return to your presentation. I just wanted to clarify whether or not we had seen this before.
Okay, so none of our exhibits have been
Well,
shown
it's in the
before.
record, but you did not have the opportunity to present it as testimony
That's right,
verbally. So
that's right.
we're familiar with this because it is in the record.
So we'll just show it again for
You
your
can show it and
reference.
interpret it and comment on it as you wish.
Okay. So, okay,
What do you want next?
I want that.
oh, I'm sorry.
So the reason I'm presenting it now is we're comparing the different boundary interpretations. And most of them contain a legal reference, but our Macaulay boundary interpretation contained no legal reference, not even a date of its redistricting. So that's why I'm doing this now.
Okay, thank you.
So original map's not available. It is on the Hamakua coast, described as from Waipio to Hilo, map 66. So you can show the quad maps now.
Okay. I can figure out how to do this.
How do I get rid of this?
Anyway, there's different maps from the judicial maps, and then there's the quad maps. And the quad maps is what I believe Waipio to Hilo, map 66 quad map, not Hilo to Kapoho, map 66 to Kapoho. If you can see there, it's Waipio isn't contained in the one in the north, down to the Hilo district, which starts at the Wailuku River, which actually begins the Hamakua coast, the fertile cliff lands that were all mostly in sugarcane production at the time. It is a leash prime agricultural land with high capacity for intense cultivation, and there is no statute of limitations limiting the time to challenge a boundary interpretation. Stingle's DR was decided quickly with prompt disposition with a 7-0 unanimous vote and decided with very little evidence. Ours has been months with hundreds of pages of factual evidence and law supporting it. And because we're accused of not having the preponderance of evidence, that's why we can continually give more preponderance of evidence. So, 2, boundary interpretation, Moragan. Moragan's boundary interpretation done in 2007, number 7-19, is just 5 miles north of us. The designation of the subject parcel was established on August 4th, 1969, stated in her boundary interpretation, and the landward portion of the subject parcel was deemed SLU agriculture, and any coastal lands from the top of the Sea Pali down was deemed SLU conservation. Moragan property also had a railroad within 300 feet of the top of the Pali that transected the ag use of the property, but top of the Pali was used as established on August 4th, 1969 by the action stated in the 1969 Boundary Review Report. It is also difficult to determine, what?
Point to it. Railroad.
Well, they can see, there's a railroad there.
He's told you.
Oh, I'm sorry. Again, I'm referring to the map. This is the Moragan boundary interpretation. And in the written part of the boundary interpretation, they list top of the Sea Pali established on August 4th.
Can you cite the exhibit number from your,
Oh,
for the
exhibit-
Moragan,
2
exhibit 2?
to the motion for reconsideration.
Correct.
It is also difficult to determine where the original line was, as the original map is unavailable. It could have been the railroad or the 200 to 300 foot contour line inland until the LUC determined it in 1999 to be the top of the poly. By use of the 1969 boundary review report as the legal authority for it to be the top of the sea poly, and on their own accord, subsequently changed the maps. We are simply requesting a new boundary interpretation using the top of the poly for our property as the correct ag conservation boundary according to the rules of the 1969 boundary review report and Hawaii's laws. 3, Macaulay. So on the screen, you can see boundary interpretation. This is for Macaulay.
And this is Exhibit 3
Exhibit 3.
in the instant docket. Yep.
Yes.
Boundary interpretation 92-48. All it says is, please be advised that the subject parcel is designated within the conservation agricultural districts, period. No date of redistricting, no legal authority, no reference to anything as to why it was put there. And it bisected, at that time, it was one big
13.
lot, not our lot and their lot. It was one large lot, and it transected the agricultural use that went straight up to the poly at that time. The commission is bound by its rules. Nakamine versus Trustees of Boundary Retirement Systems explains a reviewing court may modify the decision and order of the agency to fashion appropriate relief where an agency, by failure to follow its own rules, prejudices the substantial rights of a party before it. Again, I only mention this to show our own frustration with trying to work legally, respectfully, and within the law for the last 8 years, just to get agricultural use. I mean, it's pretty bizarre, I think. Anyway.
Ms. Hildal,
I'm
your
sorry.
editorial comment notwithstanding, we understand the frustration you may have,
Yes,
and it's shared throughout the room.
okay. For 205-41, Declaration of Policy, it is declared that the people of Hawaii have a substantial interest in the health and sustainability of agriculture as an industry in the state. There is a compelling state interest in conserving the state's agricultural land resource base and assuring the long-term availability of agricultural lands for agricultural use to achieve the purposes of conserving and protecting agricultural lands, promoting diversified agriculture, increasing agricultural self-sufficiency, and ensuring the availability of agriculturally suitable lands pursuant to Article 11, Section 3 of the Hawaii State Constitution. Number 5, and you can see it on the,
This is Exhibit 5 that's now on the screen.
This isn't an exhibit. This is,
no, this is not, we're doing 205-2.
oh, 205-2.
We're confused. Ms. Hildal, will you clarify what you have on the screen?
Yeah, I'm trying to put on HRS 205-2A3, which is another law that's very clear about protecting agricultural land. HRS 205-2A3, basically in effect, although different in a different wording, since 1963, in effect now, and at the time of the boundary interpretation and at the time of supposed redistricting, the laws really haven't changed. It's the maps that were to reflect those laws and rules that have proven inconsistent with the laws over time. In the establishment of the boundaries of ag districts, the greatest possible protection shall be given to those lands with a high capacity for intensive cultivation, not conservation land. Ours is prime and in intensive ag use at the time, and even special assessment ag dedicated land. Ken actually mentioned this law over 40 times in our petition and brief, as an applicable legal authority, but it was never referred to once in the final order as if it did not apply to the commission in this case. The rules under which the property was to be districted and the maps to be made. Number 6, boundary review report.
That's number 7.
Page 3. Now, these were the rules that
What
were
exhibit is this?
19, it's number 6.
Exhibit 6 is on the screen.
In the motion, it's going to be up around, I can't tell you exactly. It's going to be around, it's called the report. Just let me, it'll take me a minute to find it.
Let's proceed under your assurance that it's one of your exhibits.
This is one of our exhibits in the motion. It's called the report, the
Thank you.
1969 report or something like that.
Very good. Let's go.
And this is page 3 of it.
1969 Boundary Review Report, page 3. This clarifies that this boundary report wasn't just recommendations. It was the actions actually taken by the LUC at the time. Chapters 4 through 7 are a summary of the recommended changes to the district boundary in the 4 counties. Since these changes were acted upon during the preparation of this report, we are able to provide the commission's decisions with respect to them. In this way, the text becomes not just a report to the commission, but a record of its actions as well. These 4 chapters are a functional necessity. In other words, this text of the report is a record of the LUC's actions in districting and from which the district maps were to be made, as testified to be fact by both Commissioner Scheuer and Ms. Cato at our last hearing. Transcript, page 107, line 9 to 12. And then 7 is further part of the 1969 Boundary Review Report, page 86. These are the recommendations to be used at the time of the redistricting. Recognition that the shoreline.
Is this one that's on the screen now, number 7?
This is page 86. It's
The
number,
report, it's that same exhibit.
Same exhibit, page 7.
page 7,
Thank you.
page 86, sorry.
Pardon.
Oh, my page 7. Yeah, and
Anyway, keep going.
recognition that the shoreline is a zone rather than a line has been the basis for recommending that the designation of the conservation district be inland from the line of wave action at various distances relating to topography and other use factors. A number of criteria has been developed as a result of a search for the physical boundaries that more easily and better designate shoreline conditions from adjacent agricultural uses and districts. Similar problems do not exist in relation to urban or rural districts along the sea because the Land Use Commission has designated shorelines in these situations as part of the urban or rural districts, and these areas are therefore under county control. 4 major conditions have been recognized and recommendations based on these conditions have been made for the new conservation district boundaries. Number 1, where a plantation, farm road, access way, or public road exists at the edge of the agricultural use within a reasonable proximity to the shoreline, it was used as the boundary between the agriculture and conservation districts.
Excuse me 1 second. I just want to clarify that you're using your time to read one of your own exhibits that's in the record, which we've already acknowledged we've read.
Yes.
So I just caution you if this is the best use of your time. We've read this.
Well, I think it is because.
Very well, you got that option. I just
Okay.
wanted to help you.
Okay. It was in the last hearing, but wasn't acknowledged. No one ever referred to it from the commission to us. We referred to it, but they kept changing to another issue. Anyways, so the first one is about, it's supposed to be on the agricultural edge, where a vegetation line such as a windbreak or row of trees more clearly writes the edge of the agricultural practice. So we had a row of trees on the edge of the agriculture.
And a cliff top.
In cases where the shoreline is bounded by steep cliffs, we had steep cliffs at the edge of the agricultural use at the top of the poly. So, and number 4, where no readily identified physical boundaries such as any above could be determined, only then a line 300 feet inland of the line action was used. And so that's not applicable to our property. 1969 Boundary Review Report,
This is
page
Exhibit 8.
36.
No, it's still the same exhibit. It's page 36.
Very well.
The shoreline.
Just give me a second.
Oh, wait, I'm on page 36, yeah.
That's where I am.
Conservation District, 1969 Boundary Review Report, page 36. The Hamakua Coast has a high rainfall between 100 and 200 inches per year. The result of such high rainfall is a landscape frequently dissected by steep-walled scenic valleys. The major valleys starting at Waipio, Ka'awali'i, then it continues down the coastline, Hakalau, Kolikoli, and ends at Wailuku, which is the border between Hilo and the Hamakua coast. Ours is between Hakalau and Kolikoli, and so that's right at the beginning of that South Hilo district. We are between Hakalau and Kolikoli, placing us on the Hamakua coast, according to the creators of the 1969 Boundary Review Report. And the last valley mentioned is actually right above Hilo, or quadrangle map 66. The Wailuku Valley is 10 miles south of us. And all of that is included in the Hamakua coast, according to their record. Number 9, quadrangle maps.
Just give me a second here.
So as you can see, Waipio starts up where the blue is. If you can refer to the screen, sorry. Waipio starts where the blue starts and then goes down to where the Wailuku River is at the beginning of the Hilo district, which is quadrangle map 66. Can you kind of circle that little square there?
Yeah, this one right here.
Yeah. And then,
Since you're trying to clarify for our benefit
yes.
where your property is,
Mhm.
can you, I'm pretty familiar. I lived in this area for 5 years.
Oh, okay.
Where is your property relative to Laupahoehoe Point?
Oh, it's south of Laupahoehoe Port.
By
It's
approximately how far?
probably 10 miles. It's between the Koli, if you're familiar with this area, you'll know the Koli Bridge, the Hakalau Bridge. We're about equidistant between those two bridges.
Thank you.
So, yeah. So that shows, and then they have the next, well, I'll get to that later. So the next paragraph in the 1969 Boundary Review Report talks about the shoreline in reference to the conservation districts. The shoreline, 1969 Boundary Review Report, page 36, continues in the next paragraph. The steep poly coast of East Kohala is presently within the conservation district. This district should be extended to include the sandy beach at Waipio and then to include the polylands of the Hamakua coast, already just described on page 36, just above in the previous paragraph. This district, using the ridgetop as a boundary line, commission action partially approved, areas in agricultural use were excluded. Our property should have been excluded and use the ridgetop as the boundary. quadrangle maps. 1969 boundary review report continues. Can you go back to the quadrangle maps? The 1969 boundary review report continues from Hilo, map 66, to Pacopoho, map 73.
Mr. Chair?
Commissioner Chang.
May I, is it Hildal?
Hildal.
Miss Hildal, may I ask you a question?
Sure.
And I appreciate the presentation and obviously the extensive work that both of you have put into this matter over the last 8 years. I will share with you what, and this is a reconsideration, but I will share with you the sentiment that I had at the original hearing. And this I read, it's from the report. The final boundaries in 1969 were the LUC's judgment as a result of considerable input from studies, site inspections, public hearings, talk with landowners, and the commissioner's own personal knowledge and experience. So a lot of what you're sharing with us, these were guidelines. But part of those guidelines, they were factors to be considered. And the difficulty that I'm having sitting 2022 is to put myself back in the place of 1969 with those commissioners. And it is very difficult to know all of the things that they considered. I'm sure they looked at all of these different, these 4 factors. So you're essentially asking us to stand in the shoes of the commissioners in 1969. And you have made very plausible arguments why it's at the top of the polyway. But I also know you bought the property knowing that it was in conservation lands. You bought the property knowing that it was, you wanted to use it for ag, but it was, portions of it was in conservation land. So I guess I would like you to help me better understand why aren't you doing this as a district boundary amendment rather than coming in as a deck action to reinterpret? You spent 8 years going through this process. Obviously, you've done a lot of work on this. So this is a reconsideration. We're not reopening the original hearing. And a lot of what you're presenting is what was presented at the last hearing. You may not have been able to physically present it, but it was made available for the commissioners to review. The reports, the various similarly situated cases that you presented to us. But the problem I have with those other cases, I don't know all of those facts. Those facts aren't before us. I don't know what those situations are. So all I can do is rely upon the record that we have and the decisions that were made by the Land Use Commission at that point in time.
Is this part of our hour?
No, I will appropriately adjust
you.
it, but Commissioner Chang, thank you for your comment. Could you just restate the specific question regarding
She's speaking about reliance.
No, she's speaking about why haven't you gone to a DBA?
Yeah, well, that is one, but it is also, I guess what I am just trying to share my own personal angst with this process, because we are now at a reconsideration and you are presenting to us information that was made available to the commission, may not have been presented as you would have wanted it to be, but it was made available to the commission. This information that you have was available at the time of the original hearing. So I guess I ask you, and I know that you're a lawyer, so you understand.
I'm
this.
not a lawyer.
Oh, I'm sorry.
Not attorneys.
Oh, I thought you were a lawyer. I thought in the previous.
Thank you very much, but
You were very eloquent. Your statements are very eloquent. I thought you were one. But I guess what I'm asking you is, you're asking us to interpret you believe an error was made in the boundary interpretation in 1969. I've read to you a statement that was made in the report about how the land use commissioners made their decision. They took in consideration all of these factors. And you're wanting us to go back and sit in the shoes of those commissioners in 1969. But I'm asking you, what is that? What are you presenting to us today that was either an error with our previous decision, was unreasonable, or
Erroneous.
unlawful? Those three things, those are the grounds upon which the reconsideration that we are looking at. So I'm asking you, could you please, because I want you to use your time very judicially. So if you could identify for me what's unreasonable, what's unlawful, and what is erroneous in our previous decision on the
So-
reconsideration.
And what about your question about why didn't they do?
Yeah, and I mean, that's ultimately the question is, you've spent 8 years on
Okay.
this interpretation.
Erroneous?
Joni will answer most of that, but I know you all think that you've read all of this, but indeed, your opening statement is evidence that you're not familiar with the report. You quoted page 85 of the report, which is in chapter 8 or 9. And that is how they came up with the recommended lines, not the approved lines. Joni referred you to page 3 of the report, which described that chapters 4 through 7 are fundamental. You have to read that because that was not just the recommended maps, that's what they actually approved. And on page 36, it says they only partially approved the recommended map from page 85, where you read that text. So on page 85, they're describing how they came up with these recommended district lines on the maps. But on page 36, it says, no, we're only going to partially approve that.
And thank you, Mr. Church. I appreciate the clarification. Nonetheless, when the commission makes its determination, it looks at everything in totality. And that's, that's how I look at it when I make a decision sitting on the commission now. We are guided by principles of law, principles of the rules and the facts before us. So I appreciate you clarifying for me, but it is still the same process that we apply. We're looking at all of those. But I also bring you back to, for purposes of the reconsideration, if you could identify what was an error, what was unlawful, and what was unreasonable about the original decision that was made by the Land Use Commission.
Thank you, Commissioner Chang. And before you respond to that,
Okay.
I'd like to take a little break
Okay,
and give you time to think about how you want to respond to that.
okay, thank you.
And we'll give you an extra 10 minutes or so. We'll adjust accordingly. So let's take a short break. It's currently 10:29. We'll reconvene at 10:39. So back on the record, can you start the recording?
Turn your.
I did.
The video on?
Oh,
So I think the question,
Okay, you may continue, Mr. Wong.
I think the question period is supposed to be after my presentation, but I'll answer those questions now for you. There was an error in law in previous hearing, not just because our video feed wasn't allowed and we weren't allowed to make our video presentation, but also because the basic issue of a declaratory ruling was only about the legal aspects of our property and why it was put into conservation to begin with, the laws. That's why Stingel's declaratory ruling was so quick, because he just said boundary review report. And this is also like 23 years later. It's not really a question of time. It's a question of, are the rules correct or not? Has the maps been made according to the legal reasons or not? And I kept saying that during our hearing, but nobody ever asked me about that question. There wasn't really a single question about the legality of the 1969 boundary review report at that time. And that's why there's an error in law.
Excuse me. I just like to clarify for the record.
Okay.
You referred to your inability to make your presentation at the prior hearing, but you were compromised because of the technical problems that were occurring at your end of the spectrum of the connection.
Well, I also.
It wasn't that you weren't allowed to do it.
Well, he cut off our video feed.
It wasn't working. We couldn't understand it because
Well, he only
it was,
gave us like 2 minutes to
it was a
figure
very
it out.
poor connection.
There were other people that were having problems, but they were patient with that and allowed them to rediscover their video feed and their
Can one of you talk at a time and not do this side by side stuff? So,
Okay.
I was participant in that hearing.
Mhm.
I couldn't, it was a Zoom hearing, if I recall. And I could not comprehend what you were trying to present. It was very distracting.
Well, we never got a chance to present it.
You got a chance. You couldn't deliver on your connection. That's my position. So let's resume the hearing today. So you can argue that we didn't allow you. I disagree with that. I think you were allowed, but your technical connection was just inadequate.
Well, we had a video conference from that same location with the same internet connection as we did
Could have
before.
been cloud cover. I have no idea.
Completely fine.
I have no idea what your problem was, but it didn't work.
Well, we were only given
But to
about
suggest
2
that
minutes to correct the problem.
But to suggest that the commission did not allow you is, in my judgment, incorrect.
Well, when you shut off somebody's video feed, I think that's, not allowing.
We didn't shut it off. It wouldn't connect.
And you shut it off.
Chair.
If you want to be argumentative, fine. You're using your time to do so.
All right. So the next thing is.
Just a second. Do you want to shift to Mr. Church at this point?
During other hearings, not this one, whenever one of the commissioners can't make a video connection,
We don't need that.
they are invited to a recess for them to make a better connection. That opportunity was not given to us.
Okay.
Proceed.
Okay. Okay, so I think there's also a misunderstanding again about what this actual reconsideration of our district declaratory order is. It's really only about the facts that determine the conservation boundary. That's it. The facts that created that. And that's why Stingles was so quick, because they could look at the boundary review report from which the maps were to be made, and they determined it within 10 minutes. And then ours, because you want to bring in all these different factors, including the things like, well, why didn't you do a DBA? Why don't you do this? Why don't you do that? Those have nothing to do with the reasons that our property was incorrectly put into conservation. That's the basis. This is the crux of this declaratory ruling.
So,
And this is what we're asking you to finally clarify this uncertainty. I can understand your positions of, wanting to understand all these other issues, but this isn't the issue for this declaratory ruling. It is an issue about a DBA, but it's not an issue for this declaratory ruling. And I'll tell
Ms.
you
Hildal,
why.
Ms. Hildal,
Yes,
Commissioner Chang asked you to, relative to the decision that was made,
yes,
to make your case today,
yes.
why that decision was unreasonable,
I said,
unlawful, or erroneous.
it's because we didn't stick to the issue of the declaratory reading. There are why didn't you have a tax number? Where's your agricultural use? All the things that we were asked by the commission was all about present day issues. They hardly ever asked.
The commission could explore for contextual reasons or other where they want to go relative to the issue.
Well, that's really not, I'll read you what a declaratory ruling is supposed to be about. Where'd it go now? It's only supposed to
The facts.
contain the facts. And the facts, it's the facts of the districting in 1969 or the boundary review. No, not the boundary review, the boundary interpretation that was given to Mr. Macaulay before. That's all it's about. Were they incorrect or correct? Period, according to the laws.
Okay.
According to the laws then, and according to your own laws at this time. So, let me see. On a petition for a declaratory ruling, the evidence is really not in dispute. The only matter for the commission to decide is the application of the law to the undisputed facts of what happened in 1969 and the boundary interpretation. So, and your other question about why didn't we do it by a DBA? We did petition for a DBA, number 2018-2805. To this day, it's been stated to be incomplete, even though we issued it 4 years ago. And on our first meeting together, you said, work with the staff. And we've been trying to work with the staff ever since that day. And it's still deemed incomplete. So we looked for alternatives. The second thing we did was ask for a boundary determination, which is supposed to be okay with just a written application, which we did, and that was ignored. And then we applied by the form for a boundary interpretation, and that was ignored. And so finally, we issued this declaratory ruling. And so what I'm saying is our frustration is working with LUC has been difficult because every step we've taken has been thwarted for some reason or another. We don't understand.
We don't have a lawyer.
Is it because we don't have a lawyer?
We've had we've had other pro se clients come before.
You speak into the microphone.
I'm sorry.
Commissioner Chang is recognized.
I'm sorry, Mr. Chair. Commissioner Chang, yes, we have had other petitioners that were pro se. I do want to ask you in response to your response to my questions. On the declaratory action that you filed, wouldn't you agree that the commission has a discretion to apply that it is the commission's responsibility and duty to apply the facts to the law, but that is discretion within the Land Use Commission to determine, because you are asking us to determine whether there was an error in the boundary map that was made in 1969. Is that what you're asking in this declaratory ruling? Okay, that's the question you've asked us. And
Excuse me, I can't hear you. Are you talking to us?
Are you speaking to the commission?
okay, so that's the question you're asking the commission under the declaratory ruling, right?
Mhm.
You're asking the commission to determine whether there was an error in the map where the line was drawn in 1969.
Or the boundary interpretation in 1999. 92, sorry.
And we determined that there was no error. We determined that the map is accurately drawn. So I guess I'm asking, so now, and then you filed a motion for reconsideration. So I guess now we're asking, this is not, a reconsideration is different from an original declaratory action. You present all the evidence. In the reconsideration, based upon that administrative rule, it is to identify for the commission the grounds upon which there was the ruling, the order or the decision was unlawful, unreasonable, or erroneous. So in many instances, it's to identify in a particular, specific findings that we made or the conclusion. So if you could, that would help me. If you could identify, because you're essentially asking us to reopen the deck action, but we've made a decision. And so if you could identify specifically, where were we in error, or where was the decision unlawful, or where was it unreasonable?
So I'll read to you the applicability of a declaratory order. An order disposing of a petition shall apply only to the factual situation described in the petition or set forth in the order. It shall not be applicable to different fact situations or where additional facts are not considered in the order exist. They'll have the same force and effect as other orders issued by the commission. So I can read out many, many examples in our past hearing where they kept referring back to issues that weren't about that declaratory order. And that's where it's erroneous. Because our video feed was cut off, for one thing, so procedurally, and also Chair Schroyer kept referring to other issues that weren't in the declaratory order and kept avoiding things like law and definition of a declaratory order and things like that that should have been applicable. He should have been bringing it up. It should have been an impartial hearing where you guys are just supposed to listen to the arguments and not direct a hearing to support your own opinions. And I feel that Chair Schroyer avoided at every chance and also tried to influence the State Office of Planning in a direction that she didn't want to go because she was just putting her facts down. And there were a couple of examples where she said, one thing, and he kept pushing it. It even says it in the transcript. I'll push you. I'll take all day and push you till I get you to say the right answer.
Perhaps I would ask that we should stick to the motion for reconsideration. Chair Schroyer isn't here today, so.
Well, that's part of the hearing.
If you are alleging that there's been misconduct by any of the commissioners, that's a different matter. But you filed a motion for reconsideration. So I want you to make the best use of your time. And if you can share with us exactly, again, for me, applying the rules for reconsideration. If you could identify the grounds that the decision that we made was in error, unlawful, and if you've done that, that's fine, then we can move on. So if you've done that, we can move on. I don't want to belabor the point.
Ken wants to answer that question.
So I want to first say that there's new evidence. We have probably 200 plus pages of transcripts from the 1969 commission hearings where it was repeated over and over and over again that no land that was in agricultural use was going to be redistricted. And that's part of our package to you. And the chair has said that you've all read that. So I'm not going to reread that. I'm going to assume you read that. It repeatedly talked about the Hamakua Coast. And the map I have here is from the planning office here in Hilo. That is what's described
What
to be,
number is this?
it's simply in our brief.
No,
It's
here.
not an exhibit. It's in our brief.
Is it on, it's in your brief?
Yeah, it's in, if you've
14.
read it, you would see this. It's in 3 places.
Very well. So he says it's in, the brief is exhibit 14 that he's referring to?
14, 14 or 15.
I don't know.
Okay.
It's listed in your list here of what we're talking about today,
Okay, proceed.
so that is what's called the Hamakua Planning District. And Joni referred to page 36 of the report, which is not what was recommended. This is what was approved. And your staff memorandum, which we've alleged was improper in several areas and omitted things. They took it and said, no, that means the South Hilo Planning District when it said it went down to Hilo. Well, if you read page 36, it's real clear. The paragraph above the one that says Hamakua Coast describes what the Hamakua Coast is. And it's all those valleys from up the top down to the Wailuka River. That is the Hamakua Coast. Page 36 describes very clearly that the Hamakua Coast lands in agricultural use were to be redistricted. And the next paragraph from Hilo to Kapoho is all new lava flow. So that land didn't have agricultural potential, but everything for the Hamakua Coast from the Wailuka River, which is the county of Hawaii's planning area right there, that whole area is Hamakua Coast. That's the Hamakua Planning District. It has nothing to do, there's nothing on page 36 that references the South Hilo Judicial District. It's irrelevant. It's
Mr. Chair, are you asserting, looking at this figure on the screen,
yes.
are you asserting that everything in yellow was in agriculture and there should be no conservation in this yellow area?
No.
Are you asserting?
No, I'm saying that on page 36, it refers to the Hamakua Coast. Okay?
Okay.
And your own staff memorandum,
What are you saying? Don't worry about that. What are you saying about this exhibit?
well, you cited it in your declaratory order. You cited exactly what they pointed to. They said, no, they didn't mean that on page 36. They meant just down to the South Hilo Judicial District, which it wasn't cited on page 36. Page 36 said it's the Hamakua Coast. That is the Hamakua Planning District for the county. Go ahead.
Actually, they referred to page 37, which we never referred to in our brief or anywhere in our declaratory ruling. They actually referred to the South Hilo Judicial District in reference to urban districts, not to conservation or agriculture, which is page 36. So 37 was not even a point.
It
in
wasn't
our
exhibited.
declaratory
Let her
ruling.
talk one at a time.
Okay, that's all I have to say.
Page 37 was not exhibited. So in your staff report, they come up with stuff from page 37, which wasn't exhibited, wasn't part of the hearing. And they refer to this South Hilo Planning District somehow as being what the report's page 36 was talking about when it said the Hamakua Coast. And they're saying in effect, and it was reflected in the declaratory order. So the error went from what you were told in the staff report, which had many errors and omissions, and you reflected that in your declaratory order. The error simply propagated. So we're talking here about the errors, if I may. 9110.5 was cited as an applicable legal authority in your decision and order. And that's for a contested case hearing. If you read 9110, all of 9110 is contested case hearings. It was cited in the declaratory order as applicable law. It was referred to by Mr. Okuda in the transcript. He said, hey, you got to have a preponderance of evidence and burden of persuasion. You have to meet that. So as an error in law, we were saying, we want to cross-examine Maki. You called people to testify. We weren't allowed to cross-examine. And under 9110, contested case rules, 3 says cross-examination of parties is permitted. So in plain English, I call it sucking and blowing. You can't do both at the same time. You
Let me
can't.
finish my presentation, please.
Well, we're going to run out of time and I want to cover these legal issues and then I'll turn it back to
Chair.
you.
Okay.
So
1 second here. You're going a little bit astray. Commissioner Axon.
Yeah, I'm just kind of getting confused on who's making presentation. I
I'd
just
like
want
to
to kind of repeat what the guy said. Presentations one at a time and keep interrupting each other. And perhaps, Mr. Chair, we can let the petitioners present their make presentations and the commissioners ask questions later.
I agree. We're going to hold
I
our
agree with
questions.
that.
Ms. Hildal, will you complete your 30-minute presentation, please?
Okay, thank you very much. So I was back on, you want to go back to the boundary review report, page
So who's making
36.
presentation now?
Ms. Hildal, Ms. Hildal is making this.
Still yet.
So I'm back to the shoreline, the 1969 boundary review report, page 36 continues in the next paragraph. So first they talked about where the Hamakua coast was from Waipio down to Waikulu River, which is just the border into the town of Hilo. And we are 14.5 miles north of the boundary of Hilo. So the shoreline, the steep poly coast of East Kohala is presently within the conservation district. This district should be extended to include the sandy beach at Waipio and then to include the polylands of the Hamakua coast. So using the ridgetop as a boundary line. So the commission action partially approved because areas in agricultural use were excluded. Our property should have been excluded and used the top of the ridge top as the boundary. Quadrangle maps. The next paragraph is about from Hilo, map 66, to Kapoho, map 73. The shore is rocky with only occasional beaches, product of recent lava flows, recommended 300 feet Malca of the high water mark, commission approved. So our area is not, shore is rocky with only occasional beaches and product of recent lava flows. Our area is a product of old lava flows with very rich, productive agricultural soils, which I'll show later. So Act 187, map soils,
okay.
slopes, and rainfall. It's the next one down.
Yeah,
right there.
so this is the cover page.
That's the cover page, and these were why the areas were put into agricultural use to begin with. Prime ag land in 187 was to be rated by these factors affecting the delineation of the agricultural district on the island, the character of the soil. That's the first one. And so ours was AB. That's the same as the Alish determinations. Kenny, what did you?
I don't know, didn't do anything.
So can you pull it down a little bit?
Just a minute, I'm shaking. There.
Okay, as you can see from Waipio down to just on the border, that's where all the good soils were. And from 14.5 miles up to Hakalau, it was all being used in sugarcane intensive agriculture. So the next picture. The next characteristic was to be slopes. less than 20%. As you can see in this map, ours was less than 10%, the slope of our property. And the third was average annual rainfall of at least 25 inches, which everybody knows Hilo in our area in particular has lots of rainfall. So it goes on to say, according to the Land Study Bureau, the land area with these characteristics, prime agricultural land, is 115,600 acres, or only 4.5% of the total island area. What was determined in this study was that prime agricultural land was only 4.5% of the total land area of this island. So those are the areas that should be protected. And that's exactly the idea of all our laws that are trying to protect agricultural land. The largest area of prime agricultural land are on the northern tip of the Kohala district and along the Hamakua coastline from Waipio to Hilo, map 66, as stated and as illustrated by its supporting maps. If you still adhere to the false premise that the Hamakua coast does not include the steep, fertile lands from Hakalau to Hilo, those exact lands would have then been the only area of shorelands neglected to be mentioned on the entire East Island shoreline and not described in the 1969 boundary review, as the next description on the map then began from Hilo down to Kapoho. The shore is rocky, not from Hakalau or Papaiku, which is our map, map 65, down because the topography isn't rocky or recent off lava flows. It's lush and fertile with high steep cliffs. And most importantly, prime ag land, alish, ag use and dedicated for intensive ag production at the time of redistricting. So that you saw the Hamakua map already. The Hamakua, yeah, you could show it again.
Quadrangle map?
Hamakua map.
Oh.
The Hamakua Development Plan implements the general plan for the region, including the districts of Hamakua, North Hilo, and what they call rural South Hilo, which is the northern part of the South Hilo district. You can see it's in green. That's the northern part of the South Hilo district, which was an intense agricultural use at the time, all prime ag land. And it's called the rural South Hilo portion of the South Hilo district, which is north of the Wailuku River. We are located 10 miles north of the Wailuku River and the rural south portion of the South Hilo district. So quadrangle maps. This, well, I'll ask. So what we think, confusion and uncertainty still exist, not from the report or from the laws, the legal authorities, which have not substantially changed over time. Greatest possible protection for prime ag lands, but from the maps. The maps have been inconclusive, not the laws, which have proven over time to be inconclusive with the report, the laws, and the interests of the state, which actually are its laws. So then I'm down to testimony by Williams and Dagenhart. This is the testimony that was made in the
What's the
beginning.
exhibit number? Transcripts? 16, that's a quadrangle. That must be the next one. Okay, let's see.
So the testimony of those people that were in the land commission at the time continually state over and over again that lands and ag use were not to be redistricted. They were supposed to be left as ag. So if you can see in these, people asked, oh, what about the 300-foot shoreline? And he said, well, in that case, if your property is in intensive ag use, it should not be redistricted. Over and over again, people ask questions. What about this and what about that? Well, if your land is in ag use, it's not to be redistricted. These are the testimonies. These are the people speaking in those meetings that were constructed to create the maps and to create the laws. So
It is flexible.
So he's talking about the boundary lines, and he's saying it is flexible in the same manner as all boundaries are upon application. We feel it is more realistic distinction between agricultural uses and the shoreline than presently exists. Find me.
So it's 11:11. We've gone.
Okay,
11
I've got just a little bit more to
Yeah,
go.
so how much more do you want to get to the end of
I've
your?
got 3 pages.
Okay, so we'll break at that point.
So you asked about reliance. Commission discussed whether the landowner had relied on state zoning when he purchased the property. Reliance is principally relevant to the question of whether a landowner has a vested right to take an action or continue a use that would not be allowed after a change in the law. Waikiki Marketplace versus Chair of Zoning explains that a landowner may rely on zoning ordinance in effect at the time, 1969 and 1992, because pre-existing lawful uses of property are generally considered to be vested rights that zoning ordinance may not abrogate. The vested rights analysis comes into play when the government unilaterally takes action against a landowner. Reliance is not a relevant inquiry where the landowner affirmatively asks the government to take action to correct an error. And that's what we're doing at this moment. Looking at this point from another angle, an error cannot be perpetuated simply because the error has been around for a long time. Estoppel does not apply in this case, as we and the previous owners are allowed by law to apply for a new boundary interpretation, petition for a DR, and to repetition for DBAs every 1 year if the first one failed, if uncertainty remains. If the SLED maps were deemed to be the final authority, the law and the commission's rules would not have availed these options to the public. We also have testimony by many officials that some district lines on the SLED maps are inconclusive. Statutes of limitations do not apply to boundary interpretations. Supposed fear of litigation, dangerous precedent, or increased workload are suppositions, not valid criteria to deny as state interests when analyzing this factual situation at the time of redistricting and subsequent boundary interpretation 9248. Even so, there's only been 2 cases we are aware of that have been brought forward, DR 9921 and DR 9617. And in both cases, the commission agreed with the petitioner, so no litigation would have been forthcoming. Litigation should not be expected if after a fair, quasi-judicial, non-adversarial meeting, hearing the commission rules impartially and according to Hawaii's Constitution, HRS 205-2A3, Acts 193, Act 187, and LUC's rules, HAR 1515-19 and HAR 1515-22, and the 14th Amendment of the Constitution of the United States are all taken into account. The citizens of Hawaii trust and depend on you to make impartial decisions based on proven facts and established policies. No litigation should ever be forthcoming unless the commission ignores their own Hawaii's Constitution, laws, and rules, which are the state's interest, and the facts of this declaratory order. Ironically, Scheuer cited relaxed allowance of building homes and residences in ag districts, which would go to the fundamental purpose that we are charged with protection. I haven't read any laws more strongly stated or clear than HRS 205-2A3 in effect now, and basically the same law that when the Land Use Commission was formed. In the establishment of the boundaries of ag district, the greatest possible protection, it's mandatory, be given to those lands with a high capacity for intensive cultivation, not conservation land. Getting our single family resident, and this is really important, getting our single family residents, which we first applied for a farm dwelling, permitted, was a relatively simple permit, but allowing the continued vested agricultural use of our property is seeming an administrative impossibility. We don't understand how the commission doesn't see how their administration has actually promoted and contributed to the relaxed allowance of building homes and scattered urban sprawl, rather than encouraging the vested ag use as its property seems to protect over anything else. What other choice does a conservation property owner have? What's really going on here is that the state's management of conservation property ultimately leaves an owner with only 3 choices, none of which support ag use. First one, scattered urban sprawl. To get a residence is a relatively easy permit process, but seemingly there's no chance to permit the historical invested agricultural use, as our expensive and time-consuming experience of 8 years working lawfully to achieve has shown. So the second choice is just simply allowing the property to go fallow with derelict cars, piles of garbage, invasives, fire ants, rats, pigs, etc., to take over because of the owner's fear of doing anything else. Even just a simple fence is a huge application that could bring on a fine. Most people choose this one because they think, oh, it's conservation land, we can't do anything, I'm not going to do it, it's too much trouble. But they actually do have vested ag rights if they stand up and fight for them. Or number three choice, sell the property and let someone else deal with the state. That was the previous owner's choice after giving up after many unsuccessful attempts for years himself, trying to get a legally viable agricultural operation going on properties with historical, legal, and vested ag use seems to be a total impossibility. So we really don't get it. We've never understood the resistance to allowing the historical, legal, and vested agricultural use that is protected by most land use laws and policies, and even mandated and use sworn oaths to protect and be given the greatest possible protection. Are those rights to be shuffled out willy-nilly to some, but not others? Or is it that the commission is averse to a perceived increased workload or setting a dangerous precedent in lieu of relying on the laws you are sworn to protect? Why so strongly stand against the historical, legal, and vested agricultural use of our prime ag land? What's the motive here? We don't understand. This is actually the crux of the matter. The State Office of Planning had no objection to our petition after having analyzed all the facts and laws. Commissioner Okuda said himself, and because of the fact that reasonable people like the Office of Planning, which has the charge of protecting the public interest and the public trust, cited the fact that the commission had discretion, Kanalua was not a reason to base a denial on. They were only stating the simple truth of the situation. The Land Use Commission always has Kanalua. They have the discretion The State Office of Planning does not have the discretion to make that decision. You have the discretion to make that decision. The truth is, as they were trying to say, it is simply the duty and the responsibility of the commission, not the State Office of Planning, to decide after hearing all the facts, including the Office of Planning's, and then impartially applying its laws and policy according to Act 193. Similarly to the State Office of Planning, we acknowledge and respect the Land Use Commission's right to discretion, as is always the case, but this discretion must also encompass its responsibility, duty, and oath of office to administer its decisions impartially and according to the state's interest, which is its laws. Mahalo for considering my opening remarks.
Thank you very much, Ms. Hildal. Appreciate it. Commissioners, any questions at this point? Commissioner Okuda.
Thank you for your presentation. And believe me, I've read everything you folks have submitted, and I've listened closely to what you've had to say. I give you credit for pointing out your disagreements with me on the standards. If I'm just a human being. So, yeah, and so our process works when everybody's willing to listen with an open mind and not get defensive. If people point out there could be an error in applicable standards or anything like that. So so believe me, your presentation and pointing out things is not taken in any negative way. But let me ask you this. Do you believe that the documents you have submitted for this, for your motion for reconsideration or your request for reconsideration, completely and accurately spells out your position? In other words, is there anything left out in any of those documents which, or any point that you believe needs to be made but is not contained in what you filed with respect to your motion for reconsideration and the exhibits therein?
Well, if I can answer that, I would say if you stick to the facts of the declaratory order, and which this is a declaratory reconsideration, then that would be the case. But if you want to go into present day situations and other facts that don't apply to this.
Yeah, I'm sorry to interrupt, but
Yeah.
let me tell you why I'm asking that question. Okay, I just want to be sure that you have given us everything you want us to consider. Because if we make a decision one way or the other, and I don't think anybody's predisposed anyway to what decision to make. I don't want somebody to say later, oh, but we had something else, and you just didn't ask about the something else. So I'm asking, is there something else that we also have to look at with respect to your motion for reconsideration, or is everything contained in what you presented?
Can I ask you a question then? Am I able to?
Well, yeah. So ask me, I'll tell you whether I feel I can answer it or not, or whether it's
Okay, so
appropriate.
my question would be, are you referring to things like you asked us before, tax numbers, present agricultural use? We'd
Well,
be happy to answer those questions again, but they don't apply to the
okay.
declaratory order.
Yeah, I don't want to get into the argument about the merits. I just want to be sure whether in your view, you have presented in your motion for reconsideration everything that you think you need to have presented with respect to the motion for reconsideration.
Can you give me an example of what may otherwise?
I don't know. I don't know. It's your motion. So I want to be sure.
Yeah,
I want to be sure that you have had the full opportunity to give us the documentation that you believe supports your motion. Okay, so is there anything else that you believe needs to be submitted to support your motion? In other words, is your motion, maybe let me ask it this way. Is your motion complete or is it not complete?
Well, I have two other presentations to give today.
Yeah, but my question is, the presentations and what you have included or you intend to include in the presentations, are all of those things included and covered in your motion for reconsideration?
I'll let Ken answer that.
Yeah, well, the answer is either yes, no, or I don't know.
Well, he'll say.
Okay,
If you include the brief in there also, yes, it's all there.
okay. So if we were to look at everything that you submitted, including, and let's just make sure that we are all on the same page. When you, Mr. Church, say the brief, can you tell me what you mean by the brief? So that we know exactly which document we're talking about.
The staff memorandum that was given to you by staff
Okay,
describes the brief and all of its elements.
okay,
So the total list is there. It's posted on your website. And to answer your question, there's nothing else out there, and we believe everything we've given to you is correct. The new things we've brought to your attention.
Yeah.
And we intend to, if we were given enough time to really get into, is the transcripts of those hearings where it was repeatedly described to landowners that that entire coastal area was not going to be redistricted above the coastal ridgetop.
okay. Well, the transcripts say what the transcripts say. In other words, if I were to tell you the transcripts say something and they really don't say those things, well, what I have to say really doesn't amount to a hill of beans, because the transcripts, as we all say, speak for themselves, or the testimony there. So again, you believe everything that you need, everything in support of your motion for reconsideration has been submitted. In other words, the record is complete, meaning whatever you filed with the Land Use Commission, and that includes your motion for reconsideration and the exhibits, everything, there's nothing else that needs to be submitted to complete that record.
Well, our objections were also submitted, so I would include those in it.
I'm sorry, can you speak louder?
Objections were both submitted, some by me and some by Ken. Our objections to the
They're in the
previous
record.
hearing, they're also submitted
You're in
to
the
the
record.
record.
Okay, and
So
there,
that's-
yeah, I'm just trying to find out,
Yeah,
and I hate to belabor the point, but I want our record to be really clear and my understanding to be really clear. There is really nothing else that needs to be submitted for us to make a decision. And let me tell you, this is not a trap question. I'm not saying, and therefore we're going to make a decision right now. That's a separate question. Okay, but I just want to make sure, are we dealing with all the pages in the book, or are there some other pages that have been ripped out or forgotten to be put in the book that we got to look at?
Well, if I can answer that, it is your staff that brought pages into the
Yeah.
final decision.
Yep, Mr. Church,
That weren't there.
yeah, I just want to know, yes, is it all complete?
We believe it's all complete, but I want to come back to your statement about transcripts. It's one thing if you find it in one spot in the transcript where someone was
Yeah.
told this or that.
Yeah, Mr. Church,
Repeatedly,
Mr. Church, I understand your argument. I don't mean to cut you off. I'm just trying to make it so that we have a possible efficient decision maker.
have it all.
And yeah, and I'm not sure whether my fellow commissioner is going to agree with me, but I'm just trying to state that out. Yeah,
So
okay.
just let me, for the record, because you were speaking over, I just heard Mr. Church say the following words: "You have it all."
That's correct.
So we have it all.
Okay,
It's
okay,
on the commission's website.
okay.
Ms. Hildal, did you want to comment?
yeah, I did.
You want to agree or disagree with Mr. Church?
Yeah, one of our biggest
Do you
problems,
want to agree or disagree with Mr.?
I kind of want to disagree until I get some clarification. One of our problems for the last hearing was whether this this hearing and even this hearing now is based on 101 ABCD. Is that how you're going to determine it?
No,
Or
Yeah.
is it preponderance of evidence, contested case?
no, I hear what the point you made about the standard of review. And I'm going to go back and reconsider what I said. Okay, because we're all human beings.
Yeah,
And frankly, and I'm, with the chair's permission, let me just say 30 seconds about something. I believe our democracy works best when we have a free discussion and people are willing to reconsider or think about whether or not what they said was really accurate or not. So I have no problem going back and checking and questioning what I have said earlier. But the only way I can do that is to be sure we have the entire record in front of us, and I understand we do. So let me ask this next question, okay? Because this is important about how certain other things are handled. Let me just ask it personally for me. Do you believe that I have shown bias towards or against you or anybody else involved in this proceeding? If you think I'm biased, tell me I'm biased, you know.
no, I think the commission may have been misled.
Okay, well, being misled is different than
Yeah.
bias.
Right,
Yeah, is it your position that we're biased?
no,
Okay, let me ask you this question, and I'm not prejudging or speaking for anybody here. Would you have an objection if instead of having a decision made today, we take some time, but not too much time, to go back, and I know this is kind of like for the umpteenth time, reading through many, many pages, and I know people.
Speak in the microphone.
Yeah, I know it means, you know, maybe going back and looking at pages, but would you have an objection if, before we enter into deliberations, we, I don't know what the proper legal term is, we go back and look at the entire record again? You know, all the exhibits, all the transcripts, all the reports, everything that you've presented. And then we have deliberations, but we probably would have to do the deliberations before 3 of the commissioners' term limit out at the end of June. I mean, would that be objectionable?
all we're looking is for an impartial decision based on the facts. And if you need more time to do that, I have no objection to that. What about you?
We would welcome it. One of the most, something that I want to try to help you with there. We started out writing these things without having a clue what a statute or an act or a rule. I mean, if you go back 2 years, some of the stuff we were writing,
Can you get to the question?
I am.
You said you would welcome it. Is there anything more you want to add?
What, I'm going to be helpful. I'm trying to be helpful here. If you would start,
I think you're taking time and we want to.
Yeah, my only question, Mr. Church, is if you had an objection, because if you had an objection to us, you know, taking some additional time before the end of, you know, before deliberating, then, you know, we'll take that position into account. It's either, yes, you have an objection, no, you don't have an objection, or you don't know.
read it from the present going backwards, because the present has captured most of the past more accurately and without a whole bunch of extra words.
Okay, thank you.
Okay.
1 second. Commissioner Wong, did you have a question?
Yeah, Mr. Chair. So does that mean Commissioner Okudo is going to make a motion for something right now
He
at this
could
point in
be.
time?
Well, I don't want to cut off the churches if they have more time that
No, they're at the end of their time.
they're at end time. Okay, well,
So I'd like to ask something. Is this a contested case hearing with the preponderance of evidence as being the ultimate
no,
result?
no,
A, B, C, or D?
no, if I can, what I am suggesting is, at least for me personally, and I plan to make a motion, if the motion passes, I will go back and look at everything you submitted, look at all the issues you raised, and based on that review, and probably a review of the statutes, maybe some appellate cases, determine whether or not reconsideration should be granted or not granted, and if it's granted, to what extent and under what circumstances. So in other words, I can't tell you one way or the other to answer your specific question, because it depends on going back and me keeping an open mind and reviewing what has been presented, the whole package.
Welcome, Nat.
Thank you, Mr. Chair. I have nothing further.
Commissioners get an opportunity to ask questions.
Yeah. So commissioners, you still have an opportunity to direct specific questions to the testimony that's been presented by the churches. So Commissioner Cabral.
Yes, I have a question. You've had a number of items on the screen here today that you've named or not named as exhibits. And you've made numerous references of not being allowed to show those in the past because of the disconnect and Zoom disconnects and living out of town and Hilo are got real problems. I agree with that, but not necessarily the commission's problem. But are any of the exhibits or the items that you put on the screen today not been presented to us in the past? I have been, in preparation for today, reviewed hundreds, if not thousands of pages and numerous maps because I'm familiar, I live on this island, I'm familiar with your area. I've sold land up there in my past, et cetera. And I'm familiar with even the landowners who owned it before you, as well as dealing with Hamakua sugar land numerous times in numerous ways. So it appears that in the papers that I have on my computer and the information that's been presented from you to the commission in the past, and even not just your maps, but a lot of your quotes and these items like you have on the screen now, that they've been given to us in the past. Is that the case that they've been given? So some of these are new?
Some of those are new. The transcripts from the meetings that took place when the boundary review report was being made.
In 1969.
Yes, those are new.
Okay.
But they're in the record.
And also
But they're in our record now.
in the Hamakua CDP.
Okay, that's my question.
In the record now, yes.
So this information on your screen was given to us before today, before it appeared on the screen.
Yes.
Okay, well, that means I have them all because I'm looking at what's on in my data given to me via you is we have received it in the past. I just want to clarify that we've received that. And then
Add a tiny bit to this. The first paragraph on page 36, there's 3 paragraphs that we brought up. And there was a lot of debate in the last hearing. What was the Hamakua coast when it said
That point has been made already.
yeah, I'm aware of that.
that we didn't highlight that first paragraph during the last
Yeah, but
hearing because we didn't think it was an issue.
Okay, I know where my office is located on the Wailuku River. I know the area you're talking about. I see it daily.
I think,
Okay,
my interpretation of what transpired with Commissioner Okuda's questions and their answers is that we have it all,
yes, okay, I just wanted to make sure. And that yeah,
including what was presented.
right, that's what I want to say is we've seen it all, so I have it all. Okay. Then my other question, this is a question. Based on the data you've given us, the entire Hamakua coast from my office in Hilo at Wailuku River, from above my office across my river, all the way past Waipio Valley, the entire coastline is agriculture. Is that what your data you're showing?
No, only,
Oh, I'm sorry, that has been in agriculture use and high AB land value. You had maps there that you showed the entire coastline to be high agriculture value, high agriculture use.
no, there's rural.
Those are new to me.
Those are, and there's urban, and that goes all the way down to the shoreline, those districts.
Okay, I'm sorry.
Only the properties that were in bona fide agricultural use that were supposed to be the top of the poly. So each property should be evaluated to its individual use to determine whether it was supposed to be put into conservation or agriculture.
Okay, well, because based on your maps, and my reading of what you've given us, that obviously some land that was gonna, if you, unless you have nothing in conservation, that entire coastline, because you're not gonna take something that's urban or rural and convert it back to conservation, something from agriculture was gonna have to become. So I'm just clarifying your maps, because you had one where the whole sweep of that is in
We're not
ag.
asking for you to do anything about any other properties but our own,
Okay,
to determine the line for our properties.
okay. Thank you very much.
Commissioner Wong,
Oh, no, thank you.
okay? Any other questions? Commissioner? So thank you for your presentation. So
Oh, can I add one other thing?
you want to add one more thing? No, we're at the end.
I know, but I
One more
had,
things have gone on for 45 minutes
I
now,
can,
so I'm going to cut it off.
but I wanted to submit these other
I'm gonna cut it off.
presentations
You had
that
your
I had.
opportunity to put those in your hour and I gave you an hour and a half. You should have done it.
Am I still allowed my half hour?
No, she used it. You used an
Again,
hour and a half of
I
your.
register my objection. I understood.
You're-
I was going to be provided a half an hour also earlier here. And if I've misunderstood that, I guess I could rely on the transcript.
You are together as a petitioner. You have two voices. I gave you an hour. You said that she would go first.
Is there any law that says we're required to only
No, I'm not.
do it for an hour?
We object.
You object to the guidance that I've given you and how I've.
Because I had some things that I would have brought out. Had I not misunderstood, and I didn't think I did, that I was going to get a half an hour.
Understood.
So there's some,
And is there any law that says we only get an
You've used
hour?
your time and we're going to move forward. And you object to how we do it. Okay. Commissioner Okuda?
I'd like to submit my
Yeah,
other briefs and
excuse me.
As records.
Excuse me. I'd like to make a motion. I move that the commission, prior to deliberation, well, let me strike that. I make this motion. Number one, we, through the executive officer, schedule a further hearing on the motion for reconsideration. Number two, and this additional time will allow all commissioners, to the extent commissioners believe are necessary, to review the entire record. Number two, that by the close of business on Monday, this coming Monday, close of business meaning, is it 4:45? 4:30 p.m.? 4:30 p.m. that the petitioners here have an opportunity to submit the statements that they made here today. May I ask the petitioners, how many total pages are your statements?
I have about 10 more pages.
Okay, 10 pages. And Mr. Church, how many pages would your statement that you wanted to say, how many pages would that amount to?
the brief that you have on file.
No,
Just a minute, the introduction chapter in the brief was my opening statement.
Oh,
So it's there.
okay.
What I'm missing at this point is I had some very specific errors in law that I thought was being asked and I wanted to say,
Okay.
and I can do that in 5 minutes.
No. I think it's more helpful. You put it in writing so that frankly, we'll have that in front of our face and it will talk to us even if you're not talking. So how many pages would what you wanted to say to us in 5 minutes or whatever comprise total?
It would simply be a summary.
I know, how many, my
Things.
question is, how many pages?
How many pages, Ken?
Well, my comments aren't going to be about,
The motion shouldn't be negotiated.
Yeah.
Give them an opportunity to submit whatever, that's what I understand. You
Okay,
have to end on Monday to submit what you want, whether or not, that's what I understand the motion is.
Mr. Higashi, let me suggest, Commissioner Okuda, that you allow them to submit whatever they want with no page limit by that deadline.
oh, okay, that's fine. So the motion, point number 2 would be the petitioners may submit whatever additional statements they intend to make
In writing.
in writing by the close of business 4:30 on Monday. And the Land Use Commission staff office must receive the submissions by that date. And number 3, that the executive officer or the staff schedule a further hearing on this matter to occur prior to the time when our 3 commissioners' term limit out.
so
Which is before June.
would that be
Right.
by email followed by USPS?
Chair, I don't believe that the petitioner should comment when the
Listen,
motion is being made.
absolutely correct. I admonish the petitioner to please be quiet. We're considering a motion being made by a commissioner.
Yes, and Mr. Chair, to clarify, that would be before June 30, 2022.
Okay,
And that's the motion.
okay, so let me see if I can. It's a 3-part motion that you would defer the hearing
June or May?
June.
June 30. You would defer the motion to allow more time for commissioners to review the record to which the petitioners have acknowledged is complete. Number 2, by the close of business Monday, 4:30 PM, the staff of the LUC must receive in writing any additional commentary you want to put on the record.
And that date would be
Monday, 5/23, I believe. it is.
Monday, 4:30. What date? June 30th?
No, May 23.
Oh, May 23. Okay.
And number 3, the executive director would schedule a follow-up, the next hearing on this matter to be on the schedule prior to June 30, 2022.
That is correct, Mr. Chair.
I'll second that motion.
Commissioner Cabral seconds the motion. Mr. Okuda, you want to speak to your motion?
I think I've said enough regarding the motion. I think this is the most efficient, fair way of handling this.
Commissioner Ohigashi.
I'm going to vote no on the motion. And the reason why I'm going to vote,
Thing on?
oh, yes, I have it on right here.
Yeah.
I don't have
Turn it
my
up.
thing on, though, my.
I'll turn it up.
And the reason I'm going to vote no on the motion is that I believe that the record is complete. I believe that the arguments made have been made before and are made in the documents provided. And I think that we have enough of a record that we are able to make a determination as soon as we can. And my hope is it today. That's my position.
Thank you, Commissioner Ohigashi. Commissioner ACZON.
Thank you, Mr. Chair. Like Commissioner Higashi, I will vote no on this motion. I believe after 8 years, the petitioner deserve a quick resolution on this. From the beginning, the chair kind of pretty much, outlined all the process. The petitioner agreed with it. And I believe, like Commissioner Agassi, the record is complete. We affirmed from the beginning, all the commissioner read all the filings, all on the record. I don't believe that, we miss anything else. So therefore, I'll be voting no on this motion.
Thank you. Mr. Chang.
I figured out. Thank you, Mr. Chair. I too will be probably am inclined to vote no because one, we've had an acknowledgement by the petitioners that the record is complete. The only additional information would have been the presentation. But we did hear most of their presentation. I also believe that a lot of the information, and I do appreciate the amount of information that has been presented, including transcripts and your arguments before us today. But I think the record is complete and sufficient for the commission to make a determination on the motion for reconsideration. Because my concern is also one of efficiency. We will have to come back to Hilo to deliberate on this matter. And there are other matters pending before LUC. I don't want to diminish how important this is, as I realize how long the churches have worked on this project. But like Commissioner ACZON, I believe we are prepared to make a decision at this time.
Thank you, Commissioner Chang. Commissioners, anybody else want to make a comment relative to the motion that's before us? Commissioner Okuda.
Thank you, Mr. Chair. Let me try to change some minds. Okay, I'm not saying that I would necessarily vote in favor of a reconsideration. And I'm not saying that just because people appear without an attorney, they deserve any special deference. Because of the fact that the rules apply to everyone equally, whether or not you have an attorney. Okay, so I'm not saying that. It's just that to whatever extent, I would like to recognize the fact that the churches have, and I hope you don't mind me calling you by a single name, the petitioners have, submitted I think with great effort what they did. And so I don't really see the harm to our operations, even though it will cause some additional work to the staff to hold this over until right before the end of June when everyone else term limits out. But I think there's no harm in going back and looking at the record one more time. I do recognize the fact that conservation land is really important. I mean, that's the reason why I know we all have concerns about when people buy property that is clearly designated conservation and later on something else, might take place. But, putting all of that aside, this record is a voluminous record. And I think under those circumstances, it's worthwhile just taking a little bit more time. It's not going to be months and months, just to go back and look at the record to assure ourselves that we're meeting the standard that we're supposed to meet. And so that's why I urge a vote to give this a little bit more time to look at it. I'll tell you frankly, my initial view coming into this proceeding after spending hours reading through the record was, yeah, we're kind of coming down the same road, but I think under the circumstances, maybe this is the one time we should go down the same road again and see maybe there's something else that we haven't seen. So that's my pitch to everyone about just give it another 1 month. Thank you.
Thank you, Commissioner Kuda. So the chair is so inclined also to vote negative on this motion. The record is voluminous. Perhaps you wanted to go through that voluminous record again. I've gone through it in detail in preparation, the record that was before us in detail before we made our decision on March 15th. There's a lot of exhibits and testimony and commentary before us subject to the motion for reconsideration. But in truth, I haven't seen or been inclined to want to go through that again. I feel I have adequate information to proceed to deliberation, so I will be voting against this motion. Anybody else? Mr. Ortnecker, please take a roll call vote on the motion.
Thank you, Mr. Chair. The motion is to continue this matter for a month and to give the petitioner the opportunity to submit additional written statements by Monday. Commissioner Okuda,
Yes.
Commissioner Cabral,
Yes.
Commissioner ACZON,
No.
Commissioner Chang,
They're on the bottom of the list.
I'd like to do a kind of little.
Commissioner Ohigashi,
No.
Commissioner Wong,
No.
Commissioner Kamakea O'Hell,
Aye.
Chair Giovanni,
No.
Commissioner Chang.
No.
Thank you, Mr. Chair. The motion does not carry.
Commissioners. Any additional questions or comments at this time? So I would like to, Commission will now conduct formal deliberations whether to grant or deny the request for reconsideration. I would note for the parties and the public that during the commission's deliberations, I will not entertain additional input from the parties or the public unless I specifically request those individuals or entities to do so. If called upon, I would ask that any comments be limited to the question at hand. Commissioners, let me confirm with each of you that you've reviewed the record and are prepared to deliberate on the subject docket. After I call your name, would you please signify with either an aye or nay that you are prepared to deliberate on this matter? Commissioner ACZON,
Aye.
Commissioner Cabral,
Yes.
Commissioner Chang,
Aye.
Commissioner Okuda,
Yes.
Commissioner Ohigashi,
Yes.
Commissioner Wong,
Aye.
Commissioner Kamakea.
Aye.
The vice chair is also prepared to deliberate on this matter.
Mr. Chair.
Commissioner Ohigashi, was that you or, oh, Commissioner Wong?
Oh, the better-
Sorry, I
The
wasn't,
better looking commissioner.
Mother, that's here. Mother, that's here.
sounded like a Dodger fan.
Chair, I move to deny this motion for reconsideration.
Thank you, Commissioner Wong. Is there a second?
Second.
Seconded by Commissioner ACZON. Commissioner Wong, would you like to speak to the motion?
Yes, Chair. I think that we have all the documents and information and all the exhibits that was provided to us, plus, I mean, everything with, and it's been 8 years that we have all this voluminous information. I reviewed all of this record and I still think I'm still in about to deny this motion. Thank you.
Thank you, Commissioner ACZON.
Mr. Chair, same as Commissioner Wong, I believe, I remember this petition from the time I got on this land use commission, and I think we kind of discussed and debate this several times already, and everything that was presented today or before today didn't change my mind. I think yeah, I'll just leave it like that. Thank you.
Thank you. Commissioners? Commissioner Ohigashi?
It's like I unmute myself. Going through the record on file. it seems to be the same record, only, it is the same record, only that we had before us, only that there was argument prepared by petitioners trying to spin or not put their understanding on that record. The commission had this understanding, had the written documents when it made its initial decision. I see nothing in there that changes that. There appears to have been additional new filings relating to certain transcripts that were taken. However, my understanding is that these transcripts were available at the time. So they weren't can't be newly discovered when they were available. They were just chosen by Mr. Church not to use it, to allow additional information into a reconsideration of a hearing that was held. I'm not too sure that it can be allowed if they were available at the time and decided strategically not to be used at that hearing. I see no basis to grant a motion for reconsideration in this matter. I believe that the commission made the right decision, and I'll be supporting the motion. As a side, the commission is concerned, I believe, all members of us are concerned about the protection of agricultural land. However, we believe conservation land is important also. And I'm of the understanding that agricultural pursuits can take place on conservation land. And in fact, I believe they are being pursued on agricultural land. And I believe this parcel itself is being used for agriculture. So I'm not afraid that this decision diminishes the commission's push for more agricultural land. It doesn't detract from it. It reduces the inventory in agricultural land. It doesn't reduce the actual use of land for agricultural purposes. Finally, I don't see this, I see this as an imperfect methodology to skirt the type of scrutiny that a DBA will provide, where we are able to seek whether or not there are significant cultural traditional practices. We have a FONSI right now, but who knows what may obtain in, we've had these type of hearings where new evidence are prepared because it is a contested case proceeding. And I think that to deprive our opportunity of that review by just declaring that this is all of a sudden agricultural sort of diminishes the role of the commission and the protection of conservation lands. No further.
Thank you, Commissioner. Commissioner Chang.
I'm gonna get another microphone next time. Thank you so very much. And to the petitioners, I have greatly appreciated your presentation and the work that you've done. I feel your frustration as well. For me, I've sat on the commission and there were many decisions, or I shouldn't say many. There were some decisions made by the Land Use Commission before us that we had to adhere to. Would I have made a different decision? Maybe so. but I have to respect the decisions that were made by the Land Use Commission at that time. I also have to believe that many of the things that you presented to us were available to the Land Use Commission when they made the boundary lines. I don't believe it was a mistake, because that's what you're asking us to determine, that there was an error or a mistake by the Land Use Commission when they drew this line. That was in 1969. I think a lot of what you presented was rather compelling. The maps you showed, the concentration of testimony. But I also have to believe that the commissioners who ultimately drew the line heard that. They received this, they looked at the same laws, they looked at the same facts that you have presented to us, was also what the commission looked at the time that the lines were drawn. Like Commissioner Ohigashi, I don't believe that your options are, by our denial of your reconsideration, it limits your ability to use the land as you intend to. I think you are frustrated because it is conservation and it's much more burdensome. And that is for a particular reason. But there's also another vehicle for you if you want to truly do ag. And you do appear to be people who want to do agriculture, that I am certain that you will find a way to do that. But I don't believe that the mistake has been made or an error has been made. So for those reasons, and nor have I been convinced on a reconsideration that you have presented to us where we were in error or where it was unlawful or unreasonable. So based upon those considerations, I am going to vote in favor of the motion. Thank you.
Thank you, Commissioner. Commissioners? Anybody else want to speak? So the chair is also going to support the motion to deny. In my judgment, I was coming here today to understand how our decision of March 15th was unreasonable, unlawful, or erroneous. What I heard instead, and what the record has shown, is that the petitioners, and I sense your frustration, I really do, really disagreed with our decision. They didn't like it. They wanted changes. And they're trying to get us to go back and reconsider all the factors that went into the decision we made at the time. The record today is very similar to the record that we had to base our decision on at the time. And my vote at the time was was consistent with the decision order which you were asked, was made on March 15th and finalized on March 15th, 2022. I very much agree with the commentary from my fellow Commissioner Ohigashi. Thank you for that perspective. But I hearken directly to what resonates with me is what Commissioner Chang brought forth earlier in her comments and again now. And that the commissioners back in the day that made the original decisions on this, it was in their judgment. And that judgment was based on I'm sure, a number of complicated factors. And they took it all into consideration. I just trust that they did. It wasn't as simple, oh, we looked at this one rule and we tried to follow that one rule. It's complicated. These matters are always complicated. So I trust their decision, and I don't feel that I've been given reason to change it. So I will support the motion. Any final comments before we take a roll call? Commissioner Cabral.
Thank you, Chair. I too am going to support the motion. As previously stated, I do not think that we made an error or that we are erroneous or that we did not have the information or that anything was done wrong on our last hearing. I do remember it well, and I know it was on Zoom, and I know that there are ways that there are technicalities that occur that may not have happened in person, but I do not believe that the commission made those errors. And so that I don't think we'd have to do a reconsideration. And I also agree with my commissioners that have commented on the decision that was made. And again, in 1969, that decision was made to zone that partial conservation. And that decision was recorded with the Bureau of Conveyances and with the state taxes. It was in that condition when they purchased the land. And so whether, again, we'd have to rethink how that decision was made, and because otherwise there'd be nothing up there of conservation or very little. So I think that it rather than try and rethink and redo everything that was done before, this is not the right vehicle to change the zoning of that land. So thank you. I will vote yes in this motion. Mahalo.
Thank you. Okay. So Mr. Orendaker, will you poll the commission on the motion?
Thank you, Mr. Chair. The motion is to deny the motion for reconsideration. Commissioner Wong.
Aye.
Commissioner ACZON.
Aye.
Commissioner Cabral.
Aye.
Commissioner Chang.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Yes.
Commissioner Kamakea O'Hara.
Aye.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 votes.
Thank you to the parties. We'll take a brief recess and then we'll move on to the next agenda item. So it's now 12:12. We'll reconvene in 5 minutes, 12:17.
178, Linda Rosehill and Third Circuit Court's findings, facts, conclusions of law, decision and order.
Thank you. Is there a second? Commissioner Axon has seconded the motion. Any discussion on the motion? All in favor of going into executive session signified by saying aye.
Aye.
Opposed? No. We'll go into executive session at this time.